I want to adopt all of Professor Roosevelt's thank yous without repeating them. At an earlier Federalist Society symposium, I was asked to discuss the question of the proper role of unenumerated rights in constitutional law. I said this was like asking me to discuss the best fuel for UFOs, which I'd have to leave to the believers. I have a similar problem here. Because constitutional interpretation is just another UFO. No issue of interpretation is actually the basis of the Supreme Court's so-called constitutional decisions. To put it in a word, the Constitution has very little to do with constitutional law. This was true of the Supreme Court's first ruling of unconstitutionality in Marbury in 1803, and it was true of its latest, Citizens United, in 2010. Judicial review, in Marbury, the court made up a statute that did not exist in order to hold that it violated a constitutional prohibition that also did not exist. Judicial review, the basis for supposed need of interpretation, was born in sin and has seldom risen above the conditions of its birth. Understanding the relevance of constitutional interpretation to constitutional law can be aided by the story of the emperor's new clothes. As you know, everyone was admiring the beautiful new clothes the emperor's clever tailors convinced him they had made for him, until some nervy brat spoiled it all by pointing out the emperor was naked. I seek to emulate that brat by pointing out that the Supreme Court is equally naked in regard to the making of constitutional law. The court wraps its rulings of unconstitutionality, which are actually pure policy judgments, in layers of constitutional prohibitions that do not exist. Compared to the court, the emperor's tailors were models of candor. The only significant difference between the emperor's tailors and the court is that once the fact of the non-existence of the clothes was pointed out, everyone agreed the emperor was indeed naked. But pointing out that the court is naked, that its rulings of unconstitutionality are simply expressions of the policy preferences of a majority of the justices, as Judge Richard Posner, for example, has repeatedly and forcefully and unquestionably done, seems to make not the slightest difference. Scholars continue to produce deep and thoughtful books and articles, and even whole conferences on methods of constitutional interpretation, apparently without ever noticing that nothing is being interpreted. The Constitution is a very short document. You all have a copy there, and it's got a lot of other stuff in it. Much of it obsolete, much repealed, easily printed on a dozen or so pages. Not at all like the Bible or the Talmud or even the tax code. Massive tomes in which many things can be found with sufficient search. Short as it is, very little of it is even purportedly involved in most constitutional cases. Most rulings of unconstitutionality involve state, not federal law. And nearly all of them purport to be based on a single sentence of a single provision, and indeed on one of two pair of words: due process, equal protection. Now, it shouldn't require jurisprudential sophistication to recognize the court does not decide difficult issues of social policy by studying those words. What do you suppose Harry Blackmun was interpreting in Roe v. Wade? Due or process? Because you got to study one of them pretty deep to get these results. The irrelevance of the Constitution, the constitutional law, can be proven scientifically. If a scientist wants to determine whether it is chemical X that causes a certain solution to turn blue, he simply compounds the solution again without chemical X. If it still turns blue, he knows that chemical X is not the operative agent. Well, everyone knows, or thinks they know, that school segregation was held unconstitutional in Brown because it violates the Equal Protection Clause. Well, what if it were possible to test that hypothesis by running the case again, this time without the Equal Protection Clause? As if to serve the cause of science, this is exactly what happened. When on the same day as Brown, the court decided Bowling v. Sharp, involving school segregation in the District of Columbia, where there is no Equal Protection Clause. Now, what difference did that make? Well, none at all. Right? School segregation was still unconstitutional. The liquid still turned blue. But now the court asserted that it was because segregation was prohibited by the Due Process Clause of the Fifth Amendment, as you all know. An amendment that was adopted in 1791 as part of a constitution that recognized and protected slavery, right? A system of thought that would not rise to the level of intellectual integrity thought necessary in astrology, but which is quite adequate for constitutional law. The real issue is not how the court should interpret the Constitution, of course, but whether it should confine itself to interpreting the Constitution rather than declaring laws unconstitutional on such non-constitutional grounds as natural law, neutral principles, tradition. Decisions made on the basis of these or any other suggested substitute for the Constitution necessarily turn out to be based on nothing but the judge's policy preferences. The bottom line, therefore, in all of this discussion is simply who should govern? Who should be making the basic social policy decisions involved here? Minimum honesty would seem to require that a law invalidated on the basis of natural law should at least be called unnatural, not unconstitutional. The only contribution the Constitution makes to most rulings of unconstitutionality is the words due process and equal protection. These words, we are told, are open-ended, hugely ambiguous, vague, vastly general, which is true, but only because the court has made them so, by depriving them of meaning and thereby converting them from rules of law to simple transferences of policy-making power. If the 14th Amendment could be returned to its original meaning, a guarantee of basic civil rights to blacks, or given any specific meaning, constitutional law would deflate like a punctured balloon. And we wouldn't have to worry about all these fine refinements of what's being interpreted somewhere. Arms, what does arms mean? Justice Hugo Black, recognizing that the court's natural law-like approach to the 14th Amendment, that is, all laws must be reasonable, it's just policy transference, of course, this deprived the Constitution of meaning, and he tried to give it meaning by having it incorporate the Bill of Rights, making Bill of Rights restrictions applicable to the states as well as the federal government. Interpreting a written Constitution is one thing, he correctly said. Declaring laws unconstitutional because unfair, unjust, lack compelling interest, whatever, is quite something else. That's simply an exercise, obviously, in lawmaking power. His argument for incorporation, however, was untenable, and the court has never adopted it. Instead, it adopted the even more untenable doctrine of selective incorporation, which has amounted to almost the same thing. Although a fanciful invention, it might be thought, the selective incorporation, to at least have the advantage that Black intended of giving the court some additional language that it could claim to be interpreting in deciding challenges to state law. This, however, is not the case. Various provisions of the Bill of Rights do clearly preclude certain policy choices.